Hello and welcome to a presentation on protecting personal data, the General Data Protection Regulation, the GDPR, and why it concerns you too. My name is Michal Ton, and I'm the legal advisor for the company Cyber Analytics. Here is what we're going to discuss today. What is the GDPR? Material and territorial scope, the definition of personal data, the main principles of processing personal data, lawfulness of processing special personal data categories, controllers and processors, the data protection officer, the DPO, rights of the data subject, penalties and enforcement, and lastly, suggestions for technological and organizational measures. Let's begin. This is how the GDPR looks like. Not very fancy. And what is the GDPR? So it's a regulation in European Union law created by the European Parliament, the EU Council, and the European Commission for the protection of personal data. It's enforceable since May 2018. The regulation addresses all things personal data, the gathering, processing, keeping, and transferring of personal data. The material scope. So the GDPR applies to the processing of personal data by automated means, partly or solely, and if by other than automated means, then intended to form part of a filing system. What is a filing system? It's the structured set of personal data which are accessible according to specific criteria. The regulation aims to give the data subject back the power, the control over his or her personal information being processed. This is the main goal of the GDPR. So what does it have to do with me? Let's talk a bit about the territorial scope. So the main thing to understand about the GDPR is that it effectively applies to almost everyone. If an organization deals with an EU member state in any capacity or processes personal data regarding data subjects who are in the EU and one subject is enough, you must observe the GDPR rules. That means that the GDPR casts a very wide net and almost everyone is included in it. So it's very important to understand, is my company or organization under the GDPR rules? Am I obliged by the GDPR requirements? So what is personal data? I've mentioned personal data a few times, but I've yet to explain what it means. Personal data is any information relating to an identified or identifiable natural person. An identifiable natural person is one that can be identified directly or indirectly by reference to an identifier. What is an identifier? It's the name and the identification number, location, or one or more factors specific to the physical, genetic, mental, economic, and so on of that person. What does it mean? It means that one factor among what you see here that is specific to that person and makes it identifiable. For example, think of genetic data. It is a factor that is specific to the identity of a person, making him identifiable. What are the main principles of processing personal data? The processing needs to be lawful, and I'll talk a bit about what makes it lawful. The processing needs to be transparent and fair. It should be collected for specified, explicit, and legitimate purposes, and those purposes needs to be detailed. The processing needs to be adequate, relevant, and limited to what is necessary. And you will see that in the GDPR is very important. You only gather information to the capacity that is necessary, and when it's no longer necessary, it must be deleted. For example, let's say you keep a customer database for sending them a weekly update or a weekly newsletter. You will only need their name and their email address. If you keep their genetic data, it will be unlawful and not for a legitimate purpose and not limited to what is necessary. And the processing needs to be accurate and, of course, when relevant, kept up to date. The processing needs to ensure appropriate security, so no breaches of the personal data will occur. What makes the processing lawful? There are 6 criteria for the processing to be lawful. Processing will be considered lawful to the extent that at least one of the following applies. So the main one and the most obvious one is consent of the data subject. Now you need to know that conditions of consent is specified in Article 7 of the GDPR. The consent should be knowledgeable, distinguishable from other matters, and used in a clearer, plain language, so the data subject knows what it consents to. If the processing is for the performance of a contract to which the data subject is party to, the concept here is similar to the first of consent, because if I sign a contract, let's say with a bank, I am knowingly giving them access to my financial data. If it is for the compliance with the legal obligation the controller is subject to, for the performance of a task carried out in the public interest, or in the exercise of an official authority vested in the controller, to protect vital interests of data subject or another natural person, and for the purpose of the legitimate interests of the controller or a third party, but provided that these interests aren't overridden by the fundamental rights and freedoms of the data subject. For example, keeping a client's database is a legitimate purpose, legitimate interest, but as long as it will not be overridden by the fundamental rights of the data subject of the clients. There are special categories of personal data, and I think the common denominator is it is all sensitive personal data. The racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health, sex life, or sexual orientation. The rule is that processing of the special categories is prohibited, but to every rule, there's exceptions to the rule, and here they are very similar to the conditions under which processing is lawful that we just saw in the previous slide. For example, the explicit consent of the data subject. Controller and processor. I think we can understand from the material scope that there are 3 main players in a GDPR: the controller, the processor, and the data subject. The data subject is obvious, so let's talk about the controller and the processor. The controller is the one that determines the purposes and means of the data processing. The processor processes personal data on behalf of the controller. Being that the controller has the more instructive, active role, it has more responsibilities. But make no mistakes. Both the controller and the processor have responsibilities to protect the personal data being processed. So the processor cannot just do whatever it wants because all the responsibility lies on the controller. Speaking of responsibilities, let's talk about what are the responsibilities both the controller and the processor have. The controller shall implement appropriate technical and organizational measures, and I'm going to say that phrase a lot during the presentation, technical and organizational measures, to ensure and to be able to demonstrate that the processing is performed in accordance with the regulation. So the main responsibility of the controller is to implement measures and to always demonstrate that it is in compliance with the GDPR. Of course, that the nature, scope, context, and purposes of processing are considered in determining which measures need to be implemented. So all measures need to be implemented, but the question is what are their scope and to what extent. The controller shall keep records of all processing activities under its responsibility, and the processor shall keep records of all the categories of processing activities carried out on behalf of the controller. So we have dual records. The controller shall only use processors that provide sufficient guarantees to implement appropriate technical and organizational measures. Please notice that the controller is the one that has the responsibility to choose the processor, and the processor will be wise in implementing those measures if it wants to be employed. How can we guarantee that both the controller and the processor know their responsibilities and know that they are liable in case that anything happens? The relationship needs to be governed by a legal act, of course, commonly by a binding contract, setting out the subject matter, the duration of the process, the nature and purpose of the processing, the type of personal data and categories of personal data. We saw earlier that there are categories of personal data, and of course the obligations and rights of each of them. In some cases, a data protection officer needs to be appointed. What are those cases? When the processing is carried out by a public authority or body, except for courts in their judicial duties. When the core activities consist of operation which require regular and systematic monitoring of data subjects on a large scale. And when the core activities consist of processing on a large scale of special categories. You remember what those categories are. And in relation to criminal convictions and offenses. These are the main duties of the DPO. He needs to inform and advise the controller, the processor, whichever one is working for, and their employees of their obligations pursuant to this regulation. He needs then to monitor compliance. He needs to cooperate with the supervisory authority and acts as its contact point. And he consults on any other matter relating to personal data protection as applicable. One of the biggest changes the GDPR brought is solidifying the rights of the data subject and essentially putting the data subject in the center and giving it many rights that it didn't have before. I'm going to talk about the 6 main rights. First, the right to access the data and the right to rectification. The data subject has the right to obtain information from the controller as to whether or not data regarding him is being processed. And if it is being processed, he has the right to access it. The data subject also has the right to obtain from the controller the rectification of inaccurate personal data without undue delay. The right to erasure and the right to restriction of processing. The data subject has the right to what we commonly refer to as the right to be forgotten, so that something you did in the elementary school won't still haunt you today. It has the right to obtain from the controller the erasure of personal data concerning him or her under certain conditions, of course, without undue delays. One of those conditions is if the data was gathered according to the data subject's consent, he can withdraw his consent at any time, and then he has the right to ask for the data to be deleted. So here I wanted to point out that the data subject can withdraw the consent to gather information regarding him at any time. It also has the right to obtain from the controller the restriction of processing, again, provided that one of the conditions laid out in the regulation applies. One condition is when the accuracy of the data is contested by the data subject. The data then will be restricted for the period enabling the controller to verify the accuracy of the data. The right to data portability and the right to be notified in some cases about a data breach. The data subject has the right to receive all the information from the controller regarding him in a commonly used machine readable format, let's say via email, and then it can transfer it to another controller because the information is his. In some cases of data breaches, mainly when there is a high risk of rights and freedoms of the data subject being affected and its personal information being unlawfully used or distributed, the data subject has the right to be notified about the breach within 72 hours. And it's a big burden to notify all the data subjects being affected within 72 hours. It's the controller's duty to make sure that all the data subjects' rights are being fulfilled. And it often means that new technological measures should be implemented, new organizational measures should be implemented, and it's usually something that the controller needs to set up for. It's not something that can happen from 1 minute to the next. So what if I don't do what the GDPR requires me to do? Let's talk a bit about sanctions, and I think I'm going to give you a pretty good incentive to follow the GDPR rules. The maximum fine for breaching the regulation is up to 4% of the annual global turnover or 20 million euros, whichever one is greater. And the enforcement already started. Here are some examples that I gathered of penalties that were inflicted. On October 30th of this year, about a month ago, the Berlin Commissioner of Data Protection and Freedom of Information issued a fine of around 14.5 million euros against a real estate company for using a system of data storage that didn't provide a possibility of removing data that was no longer required. Let's rewind back a few minutes ago. I told you that the deletion of data that is no longer required is very important in the GDPR, and now we can see that it can cost a lot of money. The Polish Supervisory Authority, also about a month ago, imposed a fine on a public entity for not concluding the data processing agreement with one of the companies that processes their data. And here I highlighted that it's a public entity, just for you to understand that all sectors, public and private, need to abide by the GDPR requirements rules. On October 30th of this year, it was a very hectic day for the Data Protection Authority of Berlin. It issues, again, a 14.5 million euros fine on a company for not complying with the data processing principles of the GDPR. And that's really just the tip of the iceberg. I just randomly chose, well, not that randomly, but I chose 3 examples. But if you go into sites that keep track of the fines being imposed, there are fines being imposed every single day and in great astronomical figures. I wanted to talk a bit about what makes the GDPR so unique. And I called it where the legal meets the technological. Though the regulation is a legal document and it uses legal terms, the applications are often technological. For example, the DPO needs to have both legal knowledge to understand the regulation and what it requires of it, and technological knowledge, understanding how to apply the requirements onto the organization's networks and databases. This makes the regulation unique in that they demand the cooperation and complementation of the legal and the IT teams. And lastly, I'm going to present a few technological and organizational measures. I said that phrase a lot, and I told you I'm going to say it a lot of times. And now I'm going to give you examples and suggestions of measures in order to better comply with GDPR. Of course, and I can't stress it enough, this is only a partial list. This is not by any means all the measures you need. The first one is encryption, and it's highly recommended using encryption because, for example, in cases of data breaches, if the data was encrypted, you don't need to notify the data subject. And we've seen earlier that it's a very big responsibility to notify all the data subjects. If the information is encrypted, there is no risk of it being unlawfully used or distributed. So the need to inform the data subject is mute. Pseudonymization, the processing in a way that the data cannot be attributed to a specific subject, and it's similar to encryption in that it makes the data sort of unusable. Automated backups of the database to ensure the ability to restore the data in a timely manner in event of an accident. Creating a detailed personal data protection policy, demonstrating the organization's responsibilities and commitment to the regulation. And I just wanted to point out that some of the measures are obligatory, like this one, and some are just suggestions of highly recommended measures. Cookie consent kit, speaking to the consent that the data subject needs to give in order to gather information regarding him. Making sure that the employees are aware of the organization's data protection policies and that they comply with them as well. Where a DPO must be appointed, it's his job. Having an inventory of the processing activities, also mandatory, as we've talked earlier. Creating a data retention schedule for how long do we keep the data for, when and why do we delete it, to avoid cases that we don't delete the data when we should and we will get a fine of 15 million euros. And lastly, preparing a comprehensive risk assessment document. Of course, many more, the list goes on and on. Thank you very much for your time. Thank you for listening. I really hope it was helpful and educational. My name again is Michal Ton. Feel free to contact me. This is my email address and this is our website. Have a nice day.